all to today's dialogue, What's Next? Bar Associations and the Pandemic Response Revisited. My name is Sarah Sanford, and I will be moderating today's discussion. This is the fourth and final dialogue of a series in which Law Asia and ABA have been exploring the threats to rule of law in Asia stemming from the pandemic and what we as bar associations can do to address those threats. This is the first collaborative series of this nature between Law Asia and the ABA and is in recognition of the very global nature of the challenges we are facing. As legal professional bodies, we at the ABA see it as our obligation to be at the forefront of these challenges along with Law Asia, helping governments and communities respond in ways that ensure meaningful access to justice, developing laws that respect human rights and promote a fair legal process, along with preserving the independence of the legal profession and judiciary. We have almost 170 people registered for today's dialogue and seen similar high interest in all previous dialogues, showing that there is broad interest in how we can be collaborating across borders to address these challenges. Our last session, held in February, focused on the use of emergency powers and executive privileges during the pandemic and the negative effects this can have on the rule of law. Vulnerable communities in particular have suffered the brunt of these challenges. Previous sessions focused on other issues, such as the negative collateral effects of rule of law of developing and adopting legislation rapidly, such as anti-doxing and laws countering misinformation. Across all three previous dialogues, we've seen cross-cutting challenges in issues related to due process and access to justice affected by shutdowns and a shift to remote hearings and representation, mostly virtual. Constitutional bases for mandates, masks and vaccinations, for example, and the use and arguably in some instances abuse of emergency authorities or legislation intended to remedy issues such as misinformation to repress political opponents. It's our hope today that we can revisit these issues, diving deeper into the nature of these challenges and refine the actionable steps we as bar associations and lawyers can take to strengthen the rule of law in our countries and across the region. For today's agenda, we'll begin with brief presentations from representatives from the US, Hong Kong, the Philippines, and Mongolia, who have been asked to talk about three different points, or four, I should say. One is lessons learned from the pandemic and how bar associations in their countries could better prepare for the next crisis. Two, how mandates such as the vaccine and mask mandates passed for health and safety reasons can comply with principles of rule of law. Three, approaches bar associations can take to combat this degradation of fundamental rights in the age of doxing and fake news. And lastly, the ways the pandemic has forced positive innovations in the panelist jurisdiction. We want this dialogue to be as interactive as possible in this virtual format. We want to hear how the experiences the panelists share compares with what has taken place in your jurisdiction. Please feel free to post comments or questions to the audience in the chat during the presentations. Our team will be asking questions as well to help inform the action report. We welcome your thoughts and reflections. You can also feel free to message Elizabeth Donkervoort or my colleague Nolan Debert privately if you wish your comments to remain anonymous. If you have a question for the panelists, please post them to the Q&A window, or you can raise your hand if you'd like to speak. We are joined by two rapporteurs who will be taking notes, and following the event, will work with Law Asia and ABA to develop an action report that distills today's discussion into best practices and lessons learned that you can take home and use in your jurisdictions. A few final housekeeping items before we get started this session. First, it will be recorded and available on the Law Asia website in the coming days. Further, if you have any technical difficulties, please contact ABA Rowley, or ABA Rowley 1 in the chat. And with that, I'd like to begin introducing our panel. Our first speaker is Victor Dawes, Chairman of the Hong Kong Bar Association. Mr. Dawes is a commercial litigator with substantial experience in a wide range of commercial and high-valued trust chancery disputes. He has appeared for a large number of financial institutions in the most significant mis-selling cases since 2008. He also has a strong ADR practice and sits as arbitrator in a wide range of commercial disputes and is on the HKIAC panel of arbitrators and the HKIAC panel for financial services disputes, as well as the SHIAC panel. He is also a member of the Proceedings Committee of the HKIAC. And with that, Victor.
Thank you very much, Sarah, for that introduction. I'm very glad to be able to share our experience in Hong Kong with those of you today. I don't have a list of everyone attending, but just looking at the names that appears in the participant or attendees list, looking from the name themselves, I can see that we probably have participants from quite a few jurisdictions. And some of you possibly from this part of the world. And just to give those of us some context of the experience we had here, because it is really, so far as the pandemic is concerned, it is really quite different from many parts of the world. When the pandemic started, of course, Hong Kong was in the thick of it because as we know, we were one of the first cities where that was affected by the initial concerns, so that there was a bit of unrest. There were also debates or disagreement as to whether the border between Hong Kong and mainland China should be shut. Now, this is, remember, at a stage where, unlike today, everybody was still flying around the world with no difficulty. Since then, since the early stage, we have all had relative stability. I think this is due to the fact that although we are a small and packed city, the system has allowed us to really have very, very effective track and trace strategy. The government also imposed, of course, to the disappointment of some people here as well, very, very strict quarantine rules for overseas travelers. So for a long time, for anyone to want to travel to Hong Kong, you have to do a hotel quarantine for anything between 7 to 21 days. So that deterred a lot of people from coming. But the flip side of that is, of course, we had a very, very low infection rate and extremely low mortality rate. Very few people died in the first 2 years of the pandemic. Now, there are, of course, pros and cons. I mean, within Hong Kong, there was a lot of freedom. There were almost no lockdown measures. We were able to travel within Hong Kong and business conducted as usual. But the problem is that this has unfortunately resulted in some complacency. And this is reflected in the very, very low vaccination rate. So we were one of the first cities that rolled out free vaccination. But ironically, because there was no local infection, the take-up rate, and particularly for the elderly, was very low. And this came back to haunt us recently. So with the Delta variant, because the border was literally shut, we've had very few imported cases. But with the Omicron variant, we were just unable to stop it. So I can say we're at a stage where I think a lot of you around the world can say we've been through the worst, we've lost loved ones, we've had very tough lockdown, but things got better. For us, it is really delayed. I mean, we don't have very strict lockdown measures, although business activities and basically movement of people are really at the lowest point in the past 2 years because of concerns of the Omicron variant. Although it is not as powerful and the sort of infection mortality rate is still relatively low, we are having tremendous problem with the old age population, and there's been very significant number of outbreaks in old age homes. So that is where we're at now. And in terms of effect on the legal system and our and legal business, it is problematic, because for the second time in the past 2 years, our courts are on a partial adjournment mode. So a lot of the civil and criminal trials have been adjourned. You can still make urgent applications, but there are multiple problems. For example, because of outbreaks of the virus in prison, a lot of the criminal trials cannot proceed. Family and friends of those who are detained are unable to visit them in the detention facilities. And there have been strong calls for more remote hearings and basically the use of technology for prison visits. On the remote hearing front, of course, we are 2 years into the pandemic, but because of the situation that we're in, there has been relatively less remote hearings compared to other parts of the world. So that has also resulted in a lot of disagreements and discontent within the profession at this stage. So I'm really speaking to you, if I may say, at a relatively sort of unsatisfactory stage for this city. Now, in looking into the future, we don't know when this is going to end. We certainly hope the pandemic will subside for Hong Kong this year. But the lesson that we have learned is that we certainly believe remote hearing should be the norm rather than the exception. Now, it is not taken up because for those of you who have visited this city, most of us are less than half an hour away from one's workplace. And so it is very difficult, very easy to get to work. And very few people actually worked at home until recently. So in light of that, the norm has been physical hearing as opposed to remote. It is partially mitigated because we do have a very strong ADR culture. So the Hong Kong International Arbitration Center is actually very active. So when there are issues in court, the arbitration community has not been affected in the same way. And just to give you an example, in 2021, the HKIAC, the Hong Kong International Arbitration Center, actually administered, they hosted 138 hearings, of which 101 were fully or partially virtual. So there were only 37 hearings that were in-person hearing at the center. So we have sort of this parallel universe where for courts, things have actually been quite slow recently. For arbitration, it has continued in full steam. The other issue that we have been looking into and we have been pushing is really the use of technology, I think, to assist those that are in detention. We really see no reason as to why the friends and relatives of those who are detained should be denied access to them, when the use of technology can almost be a complete answer. So phone calls and basically electronic means are not widely used, and we simply cannot see why that is the case. Now, moving on to another aspect, vaccination and mask mandates or vaccine passport. Hong Kong has rolled out a vaccine passport recently. So in order to visit those shopping malls, government buildings, you would need to be vaccinated now. That has unsurprisingly resulted in a few court challenges. They are really in the pipeline, so we don't really have any decided cases on this. There has not been issues with wearing masks, unlike many other countries where people are more reluctant. I think it's partially because of experience in Hong Kong. Remember, we had a very deadly disease. We had SARS in 2003. Now, that only affected this part of the world. But I think that has, in a way, prepared Hong Kong. And there's really this mentality of protecting oneself, and everyone thought masks was effective. So we don't have issue with in that regard. On vaccination, it is not compulsory, it is encouraged, but because of vaccine passport and because of the high mortality rates among old people, there are issues being taken up. There are judicial review proceedings where these measures are being challenged. As I said, although there is no local jurisprudence on this, typically in this type of court proceedings, the Hong Kong court actually plays considerable focus, or they look towards European jurisprudence to see what are the trends and what are the relevant principles. And in that regard, the authority that I thought will be most relevant and will certainly be featured heavily is 2021 authority in the in ECHR on the case concerning the Czech Republic, where the decision to measures put in place in respect of vaccination of children were placed under challenge. Now, in that decision, which I believe the organizers would share with the participants in the notes to this session, the Grand Chambers of the European Court of Human Rights actually wrote in my view, a very balanced and a very reasoned judgment on Article 8 rights, right to respect for private life. The context of that decision, which I'm just going to spend a couple of minutes on, is that in Czech Republic, there's a general duty to vaccinate children against 9 common diseases known to medical science. I mean, compliance with the duty cannot be physically enforced, so very much like the situation here. But parents who fail to comply without good reasons can be fined, and non-vaccinated children are not accepted in nursery schools. So that was the backdrop to that legal challenge. And the court pointed out that under its case law, compulsory vaccination as an involuntary medical intervention represents an interference with the physical integrity and thus concerns the right to respect for private life, which is protected by Article 8 of the Convention. At the end of the day, the legal challenge in that case failed. It was said that the measures that were put in place were only to do with 9 diseases, which vaccination was considered effective and safe by the science community. And the court also examined what is known as the proportionality requirement of the vaccination policy. And it was expressed that on the general level, the scope and content of the duty to vaccinate, the existing exception from it, and the procedural safeguards were all available. And it found that challenges to the instructional arrangement in place in the Czech Republic and to the effectiveness and safety of the vaccines in question had not been established. Now, insofar as that decision is concerned, although it's not binding in Hong Kong, I can see that it will have strong influences on how we are going to approach the matter, because in the context of Hong Kong, it is really the old and the vulnerable who are more reluctant in receiving vaccination. Insofar as the working workforce, insofar as the most adults are concerned, that there is really no hesitation in vaccination. And I can see the court following a similar sort of argument or similar sort of reasoning if the issue is being brought to court here. Now, that's of course something that is to be decided. Looking forward, there are a few common concerns to do with the pandemic. I don't think Hong Kong, the situation here will be very different. The push for use of technology, the wider use of remote hearing will continue. The other issue that we've had is because of Hong Kong being Hong Kong, and because we are part of China, although with our own legal system, with being a special administrative region with a high degree of independence, matters are dealt with, as you can imagine, quite differently. But there's always, of course, because of the fact that we're one country, people tend to look towards the other side of the border and see basically what's coming and what are the measures that are put in place in China, mainland China. And people will ask, look, is something similar going to be done? And one of the hot topics is, of course, track and trace, because we've been so successful in track and trace of infected individuals. The concern is, of course, whether the effectiveness will be translated into a tool that would be abused. There's been quite a lot of debate on that. What is currently being used in Hong Kong is, I understand, different from the mainland insofar as tracking is concerned. So technically, we can't be traced simply because we have switched the app on our phone on. But this is, of course, something that we will be watching very closely as an association. And of course, the rights of those who are detained is something that is very close to our heart. There's been a lot of discussion about the use of smart prison, use of technology in prison, and that is something that we believe is feasible and ought to be encouraged. We don't know when the next pandemic is going to hit us. Well, put it this way, I might be going a step too far. We don't know when the current pandemic will end for us. I hope it will end relatively quickly. But I think we would all appreciate and understand we really need to prepare for the next pandemic. I think it is disappointing in a way that Hong Kong being somewhere where we had the experience of the last pandemic in 2003, which was a very deadly disease. A lot of measures were debated, resources were allocated to look into various measures, but I think everyone just got a bit complacent. But with this experience, I hope we will be prepared for the next battle if there is one. So on that note, I better end my bit because I see that I've already overran. And sorry for taking up so much time. Thank you very much for listening. I look forward to discussing various issues with all of you.
Thank you very much, Victor. Our next presenter is Professor Renee Landers. Professor Landers is a professor of law, faculty director of the Health and Biomedical Law concentration and the Masters of Science in Law, Life Sciences program at Suffolk University Law School in Boston. She's been the president of the Boston Bar Association and held numerous positions within the American Bar Association, including chair of the section of administrative law and regulatory practice. She served on the task force that drafted the revised Massachusetts Code of Judicial Conduct, effective in 2016, and currently is a member of the Committee on Judicial Ethics, which advises judges on compliance with the code. Professor Landers has worked in private practice and served as a deputy general counsel for the U.S. Department of Health and Human Services and as deputy assistant attorney general in the Office of Policy Development at the U.S. Department of Justice during the Clinton administration. She is the author of articles on the potential for Massachusetts healthcare reform initiatives to eliminate racial and ethnic disparities in healthcare and aspects of the Affordable Care Act. In addition to healthcare, Professor Landers has written on diversity in the legal profession and privacy, and is a regular commentator on legal developments in constitutional law, health law, and the administrative law for media organizations. Professor Landers.
Thank you so much for that really nice introduction. And it's a pleasure for me to be here. I'm actually not in Boston today. I am in Madrid with a group of students on a spring break study tour where we're examining some of the issues with the healthcare system and privacy regulation in Spain. I am happy to be able to talk about these issues, and I think my comments are going to parallel Victor's very closely. I think that I will sort of start where Victor left off, that bar associations have an opportunity right now in the current environment to work with legislatures and executive branch officials to review some of the statutory authorities relating to emergency powers, and to update them and clarify roles of the branches of governments and specify standards and circumstances under which it's justifiable to impose restraints on individual liberties. The statutes in the United States governing many of these circumstances, emergency powers of governors of the states, what the authority of the federal regulatory agencies might be, are dated and do not really anticipate public health or other emergencies that might have a more extended duration other than, a very limited period of time. And as Victor noted, we are now 2 years into the pandemic, which does seem to be waning in most parts of the world. Going forward, knowing, taking the lessons from our recent experience, these statutes really, revisions to the statutes should really consider whether they are sufficiently specific about what authorities the state and federal governments have to protect the community from harm, what authorities the executive branch may have if the legislature fails to take action that may seem warranted in a particular situation, or the legislature is unable to act. And I think that the organized bar associations could be really helpful in ensuring the constitutionality of these statutes. One other issue that has come up in the United States is, the extent, how courts and how government agencies should consider science in developing responses to these public health threats, and the extent and obviously one of the issues that has been of concern in the current pandemic is that we were learning as we went. The science was evolving as we learned more about the COVID virus and the vaccine development process. So this created in the United States some sense that, among the public, that they were uncertain about what the advice was from public health authorities and what the and what people were supposed to do to comply and to avoid public health threats. And I think that, bar associations could do a great deal to explain that, sometimes at the beginning of these processes, it would be nice to have clear answers and to know what the answers are and to give clear instructions to the public. But sometimes, the information is evolving and that is not possible. And the public has to understand that that there is some uncertainty in some of these situations. Another area that has come up in the United States is the use of emergency orders and to implement public health measures, which in the short term is a practical response to urgent health threats. But to the extent possible, bar associations and the legal profession generally should urge, I think, in the future that authorities use the usual administrative procedural processes to provide the public and affected interests the opportunity to participate in the process for deciding what the constraints should be and to inform, to allow the public to be able to inform the agency about the effects the government may not have considered, to propose alternatives for the government to consider. And in the United States, there's a federal statute, the Administrative Procedure Act, which specifies the mechanism for the government agencies to use in proposing regulatory measures. And it requires a public notice and comment process. There is an exception, and most states have a very similar, all the states have a very similar statute. And most of these statutes have an exception to the notice and comment rulemaking process for good cause, which means that the notice and comment process can be avoided if it is impracticable, unnecessary, or contrary to the public interest. And obviously, when the need to institute public health measures arises very quickly, and it's important to put them in effect immediately, that would be a circumstance which ordinarily the courts would say constitutes good cause for avoiding some of those notice and comment procedures. But it's also possible for agencies to issue orders under the good cause exception on a temporary basis, and to institute an opportunity for notice and comment after the orders have been, instituted, and therefore then the public would have an opportunity to respond to the constraints or to the regulations, and have an opportunity, and give the agency an opportunity to make any revisions that might seem useful or warranted. So, and then generally speaking, the courts have been very have construed the good cause exception pretty strictly. But as I said, in the context of a public health pandemic, courts are likely to consider that agencies can, at least initially, bypass the notice and comment, a notice and comment rulemaking process in order to institute regulatory constraints. And I think that the Bar Association should help ensure that agencies do try to take into account public comment at some point in these processes. Then going back to the science, one of the concerns raised often in these situations is that, that the measures, as Victor noted, could be perhaps disproportionate to the public health threat or the risk to the public. And so I think that the organized bar should require and should really work to demand that agencies instituting these authorities actually base their constraints on individual liberties in actual factual findings based in the science about, the transmissibility of the diseases, the efficacy and safety of vaccines, and that courts who, in reviewing agency decisions like this, are increasingly looking to make sure that the agency has done its homework and has made justified the actions that have been taken. So then I'll move on to the next comment about one of the questions that we had about the problem of doxing and fake news, which obviously has been a problem in this public health emergency. So that there are several defamation actions pending in the courts of the United States against a variety of entities, organization called Project Veritas, Fox News, One American News, the Gateway Pundit, that are, and the accusation, the allegation in the litigations are that the news organizations intentionally promoted and profited from false claims of voter fraud during the 2020 election, which actually sowed the seeds for a lot of distrust about some of the government responses to the pandemic. And by perpetuating this false information, these false allegations, the civil servants who run elections and businesses that provide the equipment, voting machines particularly, have been unfairly harmed. So it's a lot of legal scholars in the United States who ordinarily side with news organizations in these kinds of matters have actually come out with statements that in some of these cases that it's likely that the plaintiffs, some of the voting machine manufacturers in the United States, some of the public officials might actually be able to demonstrate that the news organizations acted and published these inaccurate reports with reckless disregard for the truth or facts and with the intent to undermine trust in the democratic process, which would countermand any kind of First Amendment right these publications have. So obviously, it's very important to ensure that just as judicial independence is important, the independence of the media also is important. But we are increasingly seeing that there is a need to kind of police the lines for fair First Amendment, the fair application of the First Amendment in the United States, which is the freedom of speech, freedom of press, and then the harm caused to the unfair harm, wrongful harm caused to the reputations of others. And I think that some of this false reporting has also, in addition to redounding to harassment and intimidation of voting regulating officials, it has also gone over and affected the activities of public health authorities. Many local public health authorities, have had their private information, their home addresses and information revealed, and many have resigned around the country, which I think is a threat for the next in looking ahead to future public health crises. With regard to vaccine and mask mandates, I think that, Victor has talked, really quite well about, the sort of concerns for the individual rights. But I think that the EU case illustrates that while people do have a right to avoid accepting medical treatment, they're receiving medical treatments, vaccines that they don't want to receive, that the governments are also entitled to impose constraints if people are posing a threat to others. One of the concerns about some of the cases in the United States regarding vaccine mandates, the federal courts and the United States Supreme Court seem to have focused entirely on the liberties of people to avoid some kinds of constraints on their activities, and have failed actually to even acknowledge the risk that these kinds of activities pose to others, that there is a countervailing liberty interest on the part of people not to be exposed and harmed by people who refuse to wear masks or receive a vaccine, or who congregate, in violation of public health restrictions. So I think that I would urge us to the legal community to make sure that sort of the side of public health is well represented in these arguments. I think also there has been in the vaccine mandate cases, the courts generally have upheld mandates for public employees. There's one case in the state where I live where the union contract seemed to have required more negotiation, but that case is still, it hasn't reached a final resolution yet. And so there has been a stay on the vaccine mandate for one of the public employee unions in the city of Boston. And then at the federal level, the United States Supreme Court has upheld the ability of the agency that regulates healthcare providers in the United States, hospitals, physicians, to require vaccine mandates for these organizations and individuals who participate in federal healthcare programs like the Medicare and Medicaid programs in the United States. But the President's authority, and the authority of the Occupational Health and Safety Administration to impose mandates in other workplaces was rejected by the Supreme Court. And I think that, again, that kind of reflects what I was saying earlier about the failure to consider the impact on others, not just on the rights of the people who don't want to have vaccines. So Victor talked about, some of the challenges to the justice system presented by the pandemic. In the United States, there have been, there's been a lot of use of alternatives to home confinement with electronic monitoring, those kinds of approaches should probably should continue for appropriate people who are incarcerated in the future, perhaps at less cost to the public, reducing the risk of these potential spread of transmission of diseases. Remote hearings can be held. One other thing I wanted to say about people in confinement, though, is that in the United States, we have this problem of privately contracted telephone services in correctional facilities, and where they charge exorbitant fees for people to stay in communication with their families. And, the legal profession could do a lot to try to eliminate those barriers to people being able to stay in touch with their family members and people in the community while they're incarcerated. I think a lot of, just quickly, I know I'm probably going over time, a lot of the remote court proceedings, I think, will continue on a permanent basis. There is no need, the system has learned that there is no need for litigants and their lawyers to come to courthouses for routine scheduling matters. And I think that I foresee that in the long term, that those kinds of proceedings will remain remote. They save a lot of time, money for clients and lawyers, and we should continue that. There is a huge backlog of cases in the courts, however, at every level, not just criminal courts, but the civil courts, the probate and family courts, which is causing great distress to the public. And perhaps the Bar Association should help the courts mount some kind of emergency action to try to get caught up. I analogize this backlog to what's going on in the healthcare, where there's been so much pent-up demand and delayed service because of the pandemic for routine matters that a lot of people are in urgent need of healthcare services because of this delay. And I think the courts are experiencing a similar backlog. So those are just a few thoughts. I guess that I would conclude by saying that even though we're all tired of the pandemic and thinking about these concerns, now is not the time to back down and to stop thinking about how to prepare for the next time. That would be a very big mistake, because I think we need to incorporate what we've learned and in planning for the future, so that the next time we're not sort of doing things on the fly and doing everything from scratch. If we have to respond to some kind of urgent situation like the pandemic, or some other kind of massive disruption to ordinary activities. So thanks very much for your attention.
Thank you, Professor Landers. I certainly agree with you that this is our opportunity to learn, and certainly hearing Victor speak of the lessons learned from SARS and how that's benefited Hong Kong is a great example of your point, I think. Our next speaker I would like to introduce is Judge Tonga. She is the head of the Mongolian Judges Association, and as a chief judge of the Civil Appellate Court in Ulaanbaatar. She has been on the bench since 2012, first at the Appellate Court of Capital City, and then the 10th Civil Appeal Court of Capital City. Prior to her judgeships, Judge Tonga was a legal officer with the Ministry of Justice and Home Affairs. Judge Tonga is also a lecturer at Sihootug University, University of Finance and Economics, and she's fluent in Russian, English, and Japanese, along with her native Mongolian. Judge Tonga, welcome. We can't hear you. Thank you.
Hello, everyone. It's 2 p.m. It's almost 2 p.m. Are you hearing me? Are you hearing me?
Yes, we can hear you now. Thank you.
Hello, everyone. It's almost 2 p.m. in our country, in Ulaanbaatar. I am now in Ulaanbaatar. So from my side, it's good afternoon, everyone. And it's my pleasure to present the situation on the case of Mongolian case of the civil countries procedure and COVID-19 situation. And I have prepared the PowerPoint file. Do you see this presentation slide?
Yes, we can see it, but also other parts of your page. So, yes.
Okay, today's my speech will be more related to the legal conflicts in civil law countries during the COVID situation, and also what the problem faces judiciary in our country, and as well as I think there would be some similar problems arising in developing jurisdictions like Mongolia. Before introducing the problem, I will briefly introduce Mongolian judicial and legal system. Our jurisdiction is more related to the connected to the civil law system, as well as everything is, we don't have precedent law like American and Anglo-American system. So all judicial work is mostly related to the, submitted under the civil code or administrative codes and statutory law. And our work is done through strictly regulated civil procedure, administrative procedure, and criminal procedure code. We have 3 courts. One is civil court, the another is administrative, and the third one is criminal court. Every court has different procedural code. So, but other regulations is statutory laws, which is regulating special subjects. So during the COVID-19, Mongolian parliament has adopted the COVID-19 law, which is named as the COVID-19 law. And this code is sometimes, this code was not so much consistent with the codes, civil codes or procedural codes, especially there were some gaps or inconsistencies with the codes that raised judiciary much problems holding our hearings and meetings and solving the disputes. For example, if I take it in a civil procedure code, this COVID law has regulated sanitary regimes, and we had the 3 different levels of regime: yellow, orange, and red. During the red regime, every movement is already prohibited. It's almost sometimes for a week and 14 days. And everything was regulated under the power of our extraordinary commission. Commission was established in a state level. It's like in the national level, then in a capital city level, and there were provinces. And this extraordinary commission has decided the quarantine regime, working hours of the offices, closing public services, and something like that. But judiciary is not included under the sanitary regime and law on COVID-19. It is partially, for example, judiciary should work even there was in a red regime. But during the procedural codes, we have some old-fashioned system, and most judicial work is based on the paper works. Most documentary evidence are based on a paper level, and personal participation is mandatory online meeting and hearing is not allowed exactly by the procedural code, but we needed some exit or to find some flexibility during this time. And during quarantine regime or COVID-19 situation, there was for judicial workers and judges, as well as for police staffs and lawyers, advocates, and notaries haven't been covered under this restriction movement regime since the judiciary should work. However, personal attendance of the people, litigants, was prohibited, not exactly directly prohibited by procedural code, however, it is prohibited by the system, like under the law of COVID and the decision of this special extraordinary commission, they couldn't come to the court. So there was, of course, it is affected to the due process of law, access to justice right, and every judicial process was delayed, and repeated postponement, rescheduling of the meeting was real problems for lawyers in Mongolia. Judiciary, how we applied the procedural code and not to breach the COVID-19 law was the real problems. And if you look, what was the situation is that since the courts was continually worked, we have 512 judges and 117 courts. Since Mongolia has a population is few, however, very large territorial country. And during the, you are seeing the dates, for example, from, it's different, it's 2020, from 2021 till now, there were locked courts were locked 57 times in the capital city, and in rural area 52 times, from 7 days for 14 days, because of this infected judges and infected judicial staffs. You can see the data. The difficulties, why it was difficult for judicial work was that I'm listed here. Since the internet work capacity speed, network speed is not so sufficient in Mongolia or in judiciary, conflicts was in legal enforcement, and there were several mandatory rules established by procedural codes, especially relating to the personal participation, not through network. Yeah, its personal participation is required in several stages, and the absence of e-court system. We have several systems, electronic systems, but it is not e-court system. We have just electronic registration or case management system. I would address it as complications in litigation process. For example, as I have said, that litigants and people should participate in judicial meeting personally. However, quarantine regime is restricting movements, so right to participate in meeting was in danger or in a problem, how to solve it. And then the delay in judicial process, since we in Mongolian, in our country, every case judiciary is obliged to solve cases within the limited period established by the law. For example, civil case should be decided within the 2 months. It can be extended for only 1 month. So within 3 months after the filing cases, we should decide the case. However, during this quarantine regime, it was almost impossible. So if the judge is breaching this period established by the law, we should be called to the it's disciplinary commission. And most of judicial work is also what judicial work is needed personal involvement is I have listed here. It's like delivering decisions should be personally in hand. And if it is really impossible, we can send it through post. And explaining rights and duties, procedural rights and duties is the obligation of the judges. It should be also done personally, face to face. And then primary introduction of the case materials to all participants. So since we don't have an e-court system, e-court materials or e-court evidence materials, every material or case is in paper. So every participant should come to the court to introduce with the case materials. And then there are some collecting evidence application is application we have judges. So for example, judge should ask witnesses and experts or something like that. All these procedural stages or procedural works should be done personally. And what was the judicial response or what judges have done is that we tried to try some flexible application of the procedural codes, for example, receiving requests, objections, and complaints through the official judicial email. However, every court has only one email. There are several or sometimes 20, 50 judges and one email. Through one email, we have been receiving requests, objections, and complaints. And holding hearings and meetings using Zoom programs. However, Zoom program is not the special platform. It's like a social. Yeah, sometimes from one side, it's a social. So it was the difficulties. And we are now connecting it to we are naming it the insufficient infrastructure. For example, as I have mentioned before, internet speed network. For example, during the hearing through Zoom, there was a weak and sometimes locks in the internet procedure, and suddenly the meeting is interrupted or it's just shut down. And then video and audio blurring. Because of that, we cannot recognize the real participant on litigants. And litigants and participants also cannot see the judges who is sitting there, what is asking. And there is also Zoom meeting. However, by the procedural code, it is mandatory that every judicial meeting should be conducted in the judicial chamber. It is like in a physical meaning. And some courts tried these Zoom meetings if there isn't any complaints from the participants. In other words, if the two participants or litigants all agreed on these Zoom meetings, we have held it. But there were some problems that some participants participated from the car, and we haven't not yet evidences from the toilet, but there were some problems, and from home and something like that. It is a real problem. Some people have been breaching the meeting rules, hearing rules, and not obeying instructions, disconnecting networks when it is not. For example, in civil cases, there are litigants, they are disputing to each other, and there is any problems, some participants has been disconnecting just networks and leaving it. And impossible to check participants. And mediation process, we have a mediation law, And in civil cases, mediation is the one of the big factors which help to decrease the judicial burden. However, mediation process should be held in a personally. So mediation process during the COVID time is already stopped, and judicial burden is consequently increased. So conflict, what we call the conflict in legal enforcement is that every court tried on its own. Some court used the Zoom program, some court is using Google Meet, and so it is not official platform for e-court or judicial system. And witnesses asked, in some courts, witnesses asked through Zoom. However, the reliability of the witness evidence is weakened. Later complaints on unofficial meeting was raised. For example, however, the participant was agreed on a Zoom meeting in the first instance courts, and then because of these problems relating to not obeying instructions, breaching meeting rules, disconnecting networks, then some participants complained into the appeal courts that the meeting was unofficial, since the meeting wasn't held in a judicial chamber. And cases including confidential materials was not able to be held through social programs such as Zoom, Facebook, or Google Meeting. And we have lessons. What was the benefits for our country or for our judiciary is that we have lessons from the COVID, that the more effort we need to introduce e-court system with the good platform and real e-court system is needed for us. And raising public awareness during the COVID, limiting fake informations and releases. So the next one is the more coordination is needed to the local authorities, government, and judiciary during this time. However, it wasn't sufficient or satisfied, I would say. And more flexible procedural law is needed. For all of these problems, it is related to the finance, legal issues, and special platform which is providing genuine e-court system and training judges and judicial administratives into the e-court system, and growing IT literacy both for the officials and publics, which I mean the litigants and participants as well as lawyers. That's all what I would say in my speech. Thank you for listening.
Thank you very much, Judge Tonga. It's very interesting. Our last speaker, but certainly not least, is Mr. Bert Estrada. He's the national president of and chair of the Board of Governors, of the Integrated Bar of Philippines. Mr. Estrada is a member of the Bukidnon Tagalonan tribe, an indigenous community in Malay City, Bukidnon. He's a Datu in the said tribe, anointed with the name Datu Manhanayan, which is in English means one he organized, fix, and prepare to arrange things. A wonderful title, I should say. Attorney Bert's father is a retired RTC judge, Benjamin Propia Estrada, who is the chieftain of the tribe. After Judge Estrada successfully secured the certificate of ancestral domain title in the tribe in 2015, Bert continued his father's work and secured confirmation of the tribe's indigenous political structure and organized the tribe's Indigenous Peoples Organization in 2017. Aside from being the Seil or assistant to his father, Bert now acts as the tribal chief Datu of the tribe and also the general manager of the tribe's own IP cooperative, which has just started to establish a 100-hectare cacao plantation within their ancestral domain. Mr. Estrada is the senior lawyer of the Estrada and Associates Law Office in Malebale City, and he is a part-time law instructor at the Bukidnon State University School of Law as well. Attorney Burt, thank you for your patience and welcome.
Thank you very much, Sarah, for that wonderful introduction. And good afternoon, everyone. Here in the Philippines, it's also 2 o'clock in the afternoon. And in behalf of the Integrated Bar of the Philippines, we're very thankful for giving us this opportunity to share with you the responses and challenges done by our law community during this time of pandemic. So let me share my screen. Are you able to see the screen?
Yes.
I'm sharing.
Yes, thank you.
All right. So I would like to share with you the responses made by the Integrated Bar of the Philippines during this time of pandemic, and specifically on the challenges on issues of due process of law and the challenges on access to justice brought about by the shutdown of our courts during the initial lockdowns brought about by the pandemic, and the challenge in the shift to remote hearings and representations done by our judicial branch government. I'd like also to discuss the constitutional basis and mandates of the government's response to the pandemic, such as the wearing of masks, and more particularly on the vaccinations, and also on the challenges that we were faced with regards abuse of emergency by certain authorities, and our intended legislations that we seek to remedy in order to address the issues on misinformation, which seek to repress not only the issues on vaccination, but only because we are in an election year, has also brought about repression of political rights and of the people. So we will also be discussing what processes the bar, the Integrated Bar, has adopted to prepare for the future crisis and the lessons that we have learned in order that we ensure that the people have access to justice even during times of pandemic such that which we have experienced, no? And also how the Integrated Bar can best promote transparency of legislative processes and law enforcement during future crises. So the COVID-19 pandemic is not only a health crisis, but has also become a human rights and justice crisis here in the Philippines, no? And I would like to believe that it's also same in most of the countries, no? And human rights cannot be an afterthought in times of crisis, but instead they must guide COVID-19 response and recovery measures. As we know by now, the virus does not discriminate, but its impact does, exposing deep weaknesses in the delivery of public services and structural inequalities that impede access to them. This unprecedented calamity presented problems that left justice systems unprepared and unable to respond. In a bid to contain the transmission of the virus, courts and halls of justices were forced on lockdowns, compelling the judiciary to look for ways to facilitate the speedy dispensation of justice while complying with constantly changing health standards. So viewing this as an opportunity to provide better service to the Filipino people, the Supreme Court Chief Justice, Alexander G. Gesmundo, envisioned a technology-driven judiciary. And in response, the Integrated Bar of the Philippines launched its Secure Justice Project on December 20, 2021. This project of the integrated bar is being conducted together with the U.S. Embassy here in the Philippines, which seeks to leverage the use of technology to extend legal services to indigent litigants through legal aid hubs, which are now currently being made in pilot areas, in chosen areas in the Philippines, and hopefully in all chapters that we have in all provinces and cities in our country, and as well as adopt and implement mediation proceedings for our Muslims and indigenous peoples and indigenous cultural communities. The Secure Justice Project will be implemented in partnership with law schools and their corresponding legal aid clinics through the mandatory clinical legal education program of the Supreme Court and their law schools curriculum. In furtherance of the same, the Integrated Bar of the Philippines Board of Governors approved an unprecedented allocation of 5 million pesos to provide gadgets, laptops to all our chapters in the provinces and provide for internet connectivity to all the offices of our chapters, so that this can become the legal aid hub where our indigent clients and even our lawyers can appear in video conference hearings with the technology and the equipment that we will be providing for our chapters. So these upgrades should provide adequate facilities for the IBP members and our indigent clients to be able to attend online hearings and consultations. In this opportune time, the IBP continuously coordinates with the Supreme Court and have our regular meetings with our Supreme Court Chief Justice and our Oversight Committee Justice. We do our meetings still online, but the importance of having an open lines of communication with the court has allowed us to also complement the efforts of our judiciary in making sure that we are able to provide access to justice to our people. So the Supreme Court of the Philippines, in partnership with Microsoft 365, also institutionalized video conference hearings for all its courts nationwide. The Supreme Court recently approved the guidelines of the conduct of video conferencing, allowing remote appearance in court proceedings from individuals across and even outside the Philippines. So right now, the Integrated Bar, we are also conducting a public information campaign and also to our members training in how to effectively use this technology and the rules that have been put in place by the court, and also educating the public on how they're able to still access justice through this remote technology and through also the Integrated Bar of the Philippines offices in the provinces. So for the first time also, the Supreme Court allowed the conduct of an online bar examination. The 2020 and 2021 bar examinations was a source of many firsts. It was the first digital examination, the first examination to be simultaneously conducted in several testing sites around the country, and the first time tests were conducted for 2 days instead of the usual 4 Sundays for a whole month. The duration of the exam was shortened, and these changes were necessary to contain and mitigate the rising cases of COVID-19 infections. Despite the challenges faced, a total of 11,378 law graduates partook of the online bar exams in 31 testing sites located in 22 local government units all over the country. Upon the request of the Supreme Court and the initiative of various chapters nationwide, the Integrated Bar of the Philippines also provided logistical support to the conduct of the examination. And it goes without saying that the IBP through its chapters, provided moral and educational support to the examinees. And because we have not produced any new lawyers for the last 2 years, we are very thankful that these innovations were done by the Supreme Court, and we are looking forward to welcoming more lawyers to our ranks who will provide the needed services to our people. So we are also painfully aware of the disproportionate COVID-19 response in certain communities, such as the targeting of vulnerable groups and the risk of heavy-handed security responses undermining the health response. Incapacitating different groups and sectors of the Filipino community with knowledge and skills on different legal and political developments, the IBP conducted several webinars and released statements aimed at discussing and explaining these legal developments. Additionally, the IBP also met with the Speaker of the House of Representatives, the Honorable Lord Alan Velasco, to discuss proposed legislation and matters concerning the legal profession. Also, with the upcoming national and local elections, pursuant to the Memorandum of Agreement signed between the IBP and the Legal Network for Truthful Elections, or LENTE, the IBP will help enlighten the public on different electoral laws, issues, and processes, including the innovations that have to be followed because of the COVID-19 pandemic, which were not needed pre-pandemic. So through our regional chapters and legal aid offices, we will also assist in filing cases against election law violators to serve as examples and deter future violations. More importantly, the IBP will pursue genuine electoral reform by gathering information before and during elections and submitting its recommendations to the legislative branch of government thereafter. In this age of advancement, where power of technology and social media is harnessed in chartering the new normal, the internet also unfortunately serves as a breeding ground for different sources of fake news, as well as mediums for degrading one's fundamental rights. With this, the IBP seeks to protect the public by implementing the following plans. First is to launch, and we have already launched, information dissemination campaigns. And second, conduct webinars for chapter officers and lawyers in general to build linkages with media houses and outlets, to fact-check news articles, especially when legal issues and implications are involved. A prime example of this would be IBP's engagement with Rappler, a local news outlet, in our Facts First PH project, which seeks to fact-check news that are found in social media. So the IBP is tasked to provide fact-checking when it involves legal issues. Of course, also continue to extend legal assistance to those whose rights have been impinged, and engage dialogues with government to convey concerns and impart suggestions to address the infringement of rights. With this, a representative from the Integrated Bar and myself is also involved in a change initiative for media self-regulation, which is being sponsored by the Swedish government to help strengthen responsible journalism and regain and protect the truth, especially this time of pandemic. So as we are still in the midst of a global pandemic, we are thankful for the numerous scientific breakthroughs such as vaccines and the use of masks and protecting us from infection as we ease into the new normal. While vaccines protect us from severe viral infections, we still have no definite or concrete answers, except that vaccines do protect us from getting infected. There is still no guarantee that vaccinated individuals can no longer be infected and in turn infect others. Limiting the movement of those with COVID appears justifiable on the ground that the virus must be contained. The unvaccinated situation, on the other hand, is different. After all, the choice to be vaccinated remains a personal matter, and protected by law. The Department of Trade of Transportation, no vaccine, no ride policy, as well as the local government units ordinances on no vaccine stay home policy order, or apparently intended to protect public health. But at the same time, they restricted an individual's right to travel or movement. Our 1987 Constitution of the Philippines provides in Section 6 of the Article 3, or our Bill of Rights, that the liberty of abode and changing the same within the limits prescribed by law shall not be impaired except upon lawful order of the court. The right to travel shall not be impaired except in interest of national security, public safety, or public health, as may be provided by law. So this was a very controversial orders coming from government, and the IBP had to step in and provide its position, and also help educate the public and remind the government of this constitutional mandate, and also of the jurisprudence in one case, Genuino versus Secretary de Lima, provides the three instances wherein one's right to travel or movement may be restricted. But as a further requirement, there must be an explicit provision of statutory law or the rules of court providing for the restriction. The requirement for a legislative enactment was purposely added to prevent inordinate restraints on a person's right to travel by administrative officials who may be tempted to wield authority under a guise of national security, public safety, and public health. This is in keeping with the principle that ours is a government of laws and not of men, and also with the canon that provisions of law limiting the enjoyment of liberty should be construed against the government and in favor of the individual. So in contrast, requiring face mask is just asking individuals to partially cover their face with a piece of cloth. And this is not the same as asking them to accept foreign substance into their bodies. And so the IBP has been supportive of the government's mandate for people to wear face masks and other health protocols such as social distancing and constant washing of hands. So on making vaccines and mask mandates and vaccine passports compliant with the rule of law, at the very least, probable cause must be shown such that in enforcing these mandates, the public interest is upheld. To comply with the rule of law, and actual law must be passed to justify mandatory compliance. Accordingly, it is the state's duty to protect the public during a pandemic, but so is an individual's right to bodily integrity. There must be a balancing of interests to which the courts are called to determine which right prevails. The IBP understands that vaccination remains the primary scientific way out of the COVID-19 pandemic and reiterates its support for the government's vaccination drive. Nevertheless, the mandatory vaccination remains to be a polarizing issue. For this reason, the IBP is active in providing its position on the legal issues surrounding vaccination, especially on policies that appear to promote mandatory vaccination. We have partnered with the medical and scientific communities in the webinars we conducted to educate our members and the public on the science behind the vaccines and the disease. It is our hope that through such partnerships, we can contribute to the shaping of needed legislation in order that we are more prepared in future emergencies, and policies will not be left to the whims of administrative officers, which is prone to abuse when there is no law that provides for the clear limit of their powers during such emergencies. From the foregoing, the judiciary has been no less than aggressive in pursuing reform initiatives and advancements that are more than effective considering the pandemic. And while it goes without saying that we are sincerely appreciative of its efforts during such challenging times, the IBP also realizes that lawyers must be more than just responsible partners in the continuing effort of the judiciary to improve the administration of justice and the upliftment of the rule of law in our country. As the country tries to find and negotiate its way to the global pandemic, which has radically changed our way of life, we remember that through our actions show that we are officers of the court and sentinels of democracy and the rule of law. And more importantly, the Filipinos duty-bound to serve the Filipino people. Thank you very much for your time in listening, and good afternoon to everyone.
Thank you so much, Attorney Burt. That's a very informative presentation. We appreciate it. I think given the hour and with 2 minutes left, I would like to just wrap up the session and invite, there's a number of questions that were in the chat, and perhaps we can circulate those to our speakers and invite their thoughts so we can put that into the written report related to this session. I'm sorry we didn't have more time to have more interaction. We really hoped for that, but with the wonderful content of the presenters, it is what it is. So, you know, I know even with that, we only scratched the surface on this dialogue. The ABA will be hosting a series of focus group discussions to explore further some of the areas addressed today. And also, if you are interested in participating in those, please email Elizabeth, see the chat. Also, please let us know in the follow-up survey what other topics you'd like to see covered in future dialogue series. We would certainly like to thank our speakers today for highlighting key challenges and providing honest analysis of the experiences of their respective jurisdictions. It sounds like many of you have been at the forefront of really helping your countries deal with these challenging times and making a difference for the people of your community. And we thank you also for your service in that way and in representing the legal profession to try to navigate these new challenges that are presented in administering justice. And we'd like to thank all of you in attendance as well for your participation today. This session will be uploaded to the Law Asia website within the next few days, and the action report will be disseminated in about a month. And as I said, we'll hope we can respond to some of the questions at that time or in conjunction with that as well. We look forward to this conversation continuing. As was mentioned by Professor Landers, now is not the time to try to forget all this, even if we all want to, but to learn from it. And we thank you all and hope you have a very lovely afternoon. Goodbye.